we have anybody from the DA's office here? I don't see anybody.
Jail's here.
I'm sorry?
I said the jail's here.
Okay, well, we're. Okay, we got Mr. Keithley, we got Mr. Keithley, you're your client, Mr. Gonzalez present, Mr. Wolf's present, okay. All right, let's go on the record and cause number D38803-CR, State versus Nehemus Antonio Gonzalez. I have counsel for both sides present, defendants present. Mr. Keithley, this is your motion for early release from community supervision, is that correct?
Yes, sir, it is. And I believe we have an agreement, Your Honor. It's my understanding an agreed order has been sent over to the DA's office. We're just waiting for signature. So I don't think there's a necessity for a hearing, Your Honor.
Well, we're doing one, but I guess Mr. Wolf, is that an agreement that you're in agreement? Are you in agreement with the motion for early release?
Yes, Your Honor, the state's in agreement. I've not yet seen his motion, but or his order, but once we get it, we'll sign off on it.
Okay, sounds good. That concludes this hearing. Mr. Gonzalez, good luck to you, sir, okay?
Thank you, Your Honor. You too, sir.
Okay, have a good day.
You too, sir. Thank you.
Give me 1 second. Okay, Barnson,
Yes, sir.
it's got wheels. It's got wheels. Okay, this is cause number D40519, State versus Christopher Barnson. Counsel for both sides is present. Defendants present. Mr. Keithley, this is your motion to withdraw.
Yes, sir. I'll rest on my motion. Text basically is that my client hasn't fulfilled his obligations for payment.
Okay. So you were retained, obviously. State have a position on the motion to withdraw.
Your Honor, I do. First, I'd point out to the court, motions are not self-proving, so one cannot merely rest on what's in their motion. But beyond that, I think waiting until we've gotten through trial announcement to then want to withdraw causes unneeded delay. Certainly, Mr. Keithley would have known far prior to this that his client had not paid him. This could not have come to as a surprise to him. And so just based on the timing of it, the state would object.
Let me take this under advisement. These are always problematic for both sides, I understand. All right, anything further?
No, sir.
No, Your Honor, thank you.
That concludes this hearing. Evan Russell?
He's in the jail, Your Honor.
May I be excused, Your Honor?
Keep in touch with your attorney. All right, this is cause number D40886, State versus Evan Russell. And I have counsel for both sides present, defendants present. Mr. Russell, is that your full and complete name? You'll have to unmute yourself, sir. Okay. Your full and complete name is Evan Ray Russell, is that correct?
Yes, sir. Evan Ray Russell.
Sir, it's the court's understanding you're here to enter a plea of guilty to the offense of possession of controlled substance, feeling group 1 greater or equal to 1 gram, less than 4 grams. Is that correct?
Yes, Your Honor.
You do understand, sir, what you're pleading guilty to?
Yes, sir.
Ms. Martin, do you wish to waive a reading of the indictment?
Yes, Your Honor, we waive the reading.
Record can so reflect. Mr. Russell, I have documents that appear to have your signature on them. They're written waivers, written plea admonishments, a waiver of your right of appeal, a judicial confession, and an evidence discovery log. Did you sign these documents?
Yes, sir, it did.
Your attorney go over them with you.
Yes, sir.
Did you understand, sir, everything that you've signed?
Yes, sir. Yes, sir. My attorney did go over everything with me. Yes, sir, Your Honor.
Do you understand, sir, you have a right to have a jury trial in this case and you're waiving that right?
Yes, sir.
You understand you also have a right to have the same jury assess punishment should you have been found guilty?
Yes, sir.
This is I'm sorry, are you a citizen of the United States?
Yes, sir, I am.
This is a third-degree felony, sir. It carries a range of punishment anywhere from 2 to 10 years in the Texas Department of Criminal Justice Institutional Division and a fine not to exceed $10,000. You understand the range?
Yes, sir, Your Honor.
The court's understanding, sir, that you've entered into a plea agreement with the state through your attorney. Is that correct?
Yes, Your Honor.
The court will not agree to be bound by the plea agreement. However, if the court follows the plea agreement, it cuts off your right of appeal except by permission of the court. Do you understand that?
Yes, Your Honor.
Are you entering your plea of guilty freely and voluntarily?
Really?
Okay, no, I mean, nobody's forced or threatened you to plead guilty. Is that correct?
No, sir, sure haven't. No, Your Honor.
And you understand the consequences, sir, of pleading guilty?
Yes, sir.
Your attorney is Ms. Martin. Are you satisfied with her representation in this case?
Yes, sir, I am.
Ms. Martin, your client certainly appears sane and mentally competent. Anything that your client has said or done that would cause you to believe otherwise?
No, Your Honor, I believe he is sane and competent.
Court this time will find the defendant is sane and mentally competent. Court will find the defendant has freely and voluntarily entered his plea of guilty, that he understands the consequences of his plea of guilty. The court will accept that plea of guilty and find the defendant guilty should the evidence prove him guilty. I have in front of me states 1, a judicial confession signed by the defendant. States he can have that exhibit admitted.
Yes, Your Honor, all offer states 1.
No objection, Your Honor.
Admit anything further from either side?
State rest.
No, Your Honor, defense rest.
They have a recommendation.
Yes, Your Honor, based on the defendant's plea of guilty and the evidence introduced, we're asking the court to find the defendant guilty of the offense alleged in the indictment and sentence him to 2 years of incarceration in the institutional division of the Texas Department of Criminal Justice. We're not seeking a fine. However, court costs in this matter are $290, and there is a request for restitution to the DPS crime lab in the amount of $180. The defendant is entitled to 109 days credit against this judgment, as is reflected on the face of the judgment.
Okay. And Ms. Martin, is that you and your client's understanding?
Yes, Your Honor, that is our understanding.
Mr. Russell, based on the evidence, the court will find you guilty of the offense alleged in the indictment. It's the judgment of the court that you're sentenced to 2 years in the Texas Department of Criminal Justice Institutional Division with court costs to be assessed, restitution as well. Any reason why sentence should not be pronounced?
No, sir.
All right, so you are sentenced to 2 years in the Texas Department of Criminal Justice Institutional Division. You'll be remanded to the custody of sheriff. It will transport you to the appropriate facility, begin serving out this sentence. This sentence begins today. You are given credit on this sentence of 109 days.
Yes, sir.
All right. Sir, in this case, you waived your right of appeal. That concludes this hearing. The bailiff will come over here later this afternoon and get your prints on the judgment, sir, and on the docket sheet, okay?
Yes, Your Honor. Thank you. Have a good day.
You too, sir. Good luck to you.
Good luck, Mr. Russell. Thank you.
Dylan Stevens. Do y'all see, oh, wait a minute. I don't see your attorney. Hang tight, sir. I'm sorry. I don't see your, he's here, but he's not here. If that makes sense. He may be in another hearing, so if not, we'll have to come back to you, sir. Just give me a second.
All right.
Judge.
Uh-huh.
Mr. Price is in county court of law in a CPS case right now.
Okay. Mr. Stevens, if you just stand down, and if you can just ask them for Guadalupe Garza. Well, hold on 1 second. Hold on. Maybe. Shelley, is Mr. Price there? Oh, no, he is. Okay. Mr. Stevens, I'll call you back here in a second, okay?
Yes, sir.
Y'all could get me Guadalupe Garza. What? He's doing the other one. Mr. Perkins?
I'm here, Judge.
Okay. We'll take up your case. Well, on some of these, I'm not, okay, never mind. I see a status waiver, but did your client do a waiver of arraignment?
I think we did one a long time ago, Judge.
Status hearing waiver, but I don't see, well, I'll tell you what, we'll just, hold on, let me look. Yeah, y'all did. It's just in one cause number, but I'm assuming it's for both.
Yes, Judge. And we would waive on the record any arraignment.
All right, I'm gonna do the two new ones first. All right, we're on the record in D40365 and D40367, both styles state versus Guadalupe Garza Jr. I have counsel for both sides present, defendants present. Mr. Garza, is that your full and complete name, sir?
Yes, sir.
Mr. Garza, it's the court's understanding in these two cases, you're wishing to enter pleas of guilty. Is that correct?
Yes, sir.
Pleading guilty to the offense of possession of controlled substance, felony group 1, less than a gram, and then prohibited substance in a correctional facility is you understand what you're pleading guilty to?
Yes, sir.
Mr. Perkins, do you wish to waive a reading of the indictment?
I do, Judge.
Record can so reflect. Mr. Garza, I have documents that appear to have your signature on them. They are written waivers, written plea admonishments, a waiver of your right of appeal, a judicial confession, and evidence discovery log. Did you sign these documents?
Yes, sir.
Did you have an opportunity to discuss these documents with your attorney?
Yes, sir.
He went over them with you. Is that correct?
Yes.
You understand that you have many rights in these two cases, one of which is the right to have a jury trial. You understand that?
Yes, sir.
You understand you also have a right to have that same jury assess punishment if you were found guilty.
Yes, sir.
Are you a citizen of the United States, sir?
Yes, sir.
All right, sir, the possession case is a state jail felony. It carries a range of punishment anywhere from 180 days up to 2 years in TDC. I mean, in state jail, I'm sorry, let me go back. 180 days up to 2 years in state jail and a fine not to exceed $10,000. You understand the range in that case?
Yes, sir.
And then the other case, sir, is a third-degree felony, punishable anywhere from 2 to 10 years in the Texas Department of Criminal Justice Institutional Division, and again, a fine not to exceed $10,000. You understand the range?
Yes, sir.
It's the court's understanding in both of these cases, sir, that you've entered into plea agreements with the state through your attorney. Is that correct?
Yes, sir.
The court will not agree to be bound by the plea agreements. However, if the court follows the plea agreements, it cuts off your right of appeal except by permission of the court. You understand that?
Yes, sir.
Are you entering your pleas of guilty to these offenses freely and voluntarily?
Yes, sir.
You understand, sir, the consequences of pleading guilty in both of these cases?
Yes, I do.
Your attorney is Mr. Perkins. Are you satisfied with his representation in these two cases?
Yes, sir.
And Mr. Perkins, your client certainly at this point in time appears to be sane and mentally competent. Anything that your client has said or done that would cause you to believe otherwise?
No, Your Honor.
Court this time will find the defendant is sane and mentally competent. Court will find the defendant has freely and voluntarily entered his pleas of guilty, that he understands the consequences of his pleas of guilty. The court will accept those pleas of guilty and find the defendant guilty should the evidence prove him guilty. In both cases, I do have states. One, judicial confession signed by the defendant. States he can have those accepted.
Yes, Your Honor.
No objection.
They're admitted. Anything further from either side?
No, Your Honor.
No, Your Honor.
All right. I have recommendations. I'll go ahead and take the state jail felony first.
The state's recommendation upon finding guilty is 12 months TDCJ state jail, $290 court costs, $180 reimbursement with jail time credit of 342 days.
Okay. Mr. Perkins, is that you and your client's understanding in that case?
Yes, Judge.
All right, Mr. Garza, based on the evidence, the court will find you guilty of the offense alleged in the indictment. It's the judgment of the court, sir, that you're sentenced to 12 months in a state jail facility with court costs and restitution to be assessed. Any reason why a sentence should not be pronounced?
No, Your Honor.
Sir, you are sentenced to 12 months in a state jail facility. You'll be remanded to the custody of sheriff who will transport you to the appropriate facility, begin serving out the sentence. This sentence begins today. You're given credit on the sentence of 342 days. Any day thereafter, you're awaiting transport to state jail. Do you understand that?
Yes, sir.
The court will make a finding at this time. You are presumptively entitled to receive diligent participation credit if and when that's received by this court. Do you understand?
Yes, sir.
In this case, sir, you've waived your right of appeal. State have recommendation in the other case.
In 40367, the state's recommendation upon a finding of the guilt is 4 years in the TDCJ Correctional Institution Division with 342 days credit.
All right. And again, Mr. Perkins, is that you and your client's understanding of the agreement?
Yes, Your Honor.
Sir, in this case, the court will find you guilty of the offense alleged in the indictment. It's the judgment of the court. You're sentenced to 4 years in the Texas Department of Criminal Justice Institutional Division. Any reason why a sentence should not be pronounced?
No, Your Honor.
Mr. Garza, you're sentenced to 4 years in the Texas Department of Criminal Justice Institutional Division. You'll be remanded to the custody of sheriff who will transport you to the appropriate facility, begin serving out this sentence. The sentence begins today. You are given credit on the sentence any day thereafter, in addition to the 342 days you've already served awaiting trial. This will run concurrently with the other sentence you just received, any other sentences you may receive out of this court. In this case, sir, you've waived your right of appeal. That concludes both of these hearings. And then finally, Mr. Garza, we got one more, and then that should be it. We'll go on the record in 39601, State versus Guadalupe Wally Garza Jr. I have counsel for both sides present, defendants present. Mr. Garza, again, just for the record, that's your full and complete name. Is that correct?
Yes, sir.
And sir, are you the same individual that was placed on probation by this court back in 2019?
Yes, sir.
placed you on community supervision in order that you comply with terms and conditions of probation. Since that time, the state has filed a motion to revoke probation, alleging that you violated terms and conditions. Is that correct?
Yes, sir.
The board understands you're wishing to enter a plea of true to those allegations.
Yes, sir.
Doing that freely and voluntarily.
Yes, sir.
And do you understand the consequences of pleading true?
Yes.
Mr. Perkins, do you wish to waive a reading of the motion to revoke?
Yes, Your Honor.
All right. Record can so reflect. Mr. Garza, I have documents that appear to have your signature on them. They're written waivers and stipulations on revocation and probation. There's a judicial confession and an evidence discovery log. Did you sign these documents?
Yes, sir.
Did you understand everything you've signed?
Yes, sir.
You understand, sir, you have a right to have a contested hearing in this case, and you're waiving that right.
Yes, sir.
Your attorney, again, on this case is Mr. Perkins. Are you satisfied with his representation?
Yes, sir.
Mr. Perkins, your client, again, appears sane and mentally competent. Anything your client has said or done that would cause you to believe otherwise?
No, Your Honor.
Court this time will find the defendant is sane and mentally competent. Court will find the defendant has freely and voluntarily entered his plea of true, that he understands the credit. I'm sorry, I'm writing the word credit, but he understands the consequences of his plea of true. Court will take appropriate action based on the evidence. I do have in front of me states one, a judicial confession signed by the defendant. Stacy can have that exhibit admitted.
Yes, Your Honor.
No objections, Judge.
It's admitted. Anything further from either side?
No, Your Honor.
No, Your Honor.
State have a recommendation.
Yes, the state's recommendation upon a finding of true. 4 years in the institutional division of TDCJ, all previous fines and court costs with a credit of 342 days given.
Okay. And Mr. Perkins, is that you and your client's understanding as well?
Yes, Your Honor.
Court this time will grant the state's motion to revoke probation. It's a judgment of the court that Mr. Garza, you're sentenced to 4 years in the Texas Department of Criminal Justice Institutional Division within the outstanding fines, court cost fees that haven't been paid to be paid. Any reason why sentence should not be pronounced?
No, Your Honor.
Court this time will sentence you, sir, to 4 years in the Texas Department of Criminal Justice Institutional Division. You remain in the custody of sheriff who will transport you to the appropriate facility to begin serving out the sentence. This sentence begins today. You are given credit on this sentence of 342 days. Again, running concurrently, sir, with your other 2 sentences you've just received. In this case, sir, you waived your right of appeal. That concludes this hearing.
Thank you, Judge.
All right, bailiff will come over here later on, sir, and get your prints.
All right. Hang on just a minute.
It looks like Mr. Price is still in that hearing, so we'll go on to Kendrick Thomas. Have y'all had an opportunity to speak?
Yes, Your Honor, but
Okay.
briefly.
Before we go on the record, I'm just trying to make sure I understand what the bond amounts are. The second degree is 50,000 and the evading is 10,000. Is that correct?
Yes, Your Honor.
Okay. All right. We will go on the record and cause numbers D40898, D40900, both style state versus Kendrick, Jermaine Thomas. Counsel for both sides is present, defendant's present. These are motions to reduce bond, and Ms. Beatty, you may proceed.
Thank you, Judge. I believe my witness is on here. I believe it's hard to see. I think she's under the iPhone.
Okay. Yes, ma'am.
Jonisha, is that you? You need to unmute.
Yes.
Okay, all right. I'd like to call Jonisha Thomas.
Okay. What, ma'am, can you state your, can you spell your name for the record, your first name?
It's Jonisha.
All right, ma'am, do you want to raise your right hand? Do you swear or affirm the testimony that you give in this case will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
You may proceed.
Thank you. Donisha, how are you related to Kendrick?
I'm his wife.
Okay. And you understand that the bond amounts are currently 50,000 and 10,000, is that right?
Yes, ma'am.
And you are requesting that those amounts be lowered, is that correct?
Yes, ma'am.
What financial means do you all have to be able to bond Kendrick out?
At the time, I only have like 1,500 at the moment, and I'm trying to. I just started working like 2 days ago, so I really don't know how much my check will be every 2 weeks. So, and I really don't have a lot of amount of money to bail him out. I'm $50,000 or $10,000 now.
Okay. So you said you just started a job. What kind of job are you working at?
At a warehouse job
At a
for the
warehouse?
time being. Yes, ma'am.
Okay. And how much do you make
Didn't
an
get that.
hour?
Y'all were talking at the same time. I didn't get that.
Ms. Thomas, can you repeat your answer again?
Which question, sir?
I'm sorry.
What you say, ma'am?
Can you repeat your answer?
It's a warehouse job.
Warehouse?
Yes, ma'am.
Okay, thank you.
Janisha, is there a place you can get to where there's light? Because I think we're all having trouble see. There you go. Right there. Stop there. And so how much are you making at the warehouse job?
It's $12.
$12 an hour?
Yes, ma'am.
Okay. And how many hours are you giving, are they giving you to work a week?
It's 30 and it's 40 every 2 weeks. 30 one week and 40 another week.
Okay, got it. So when Kendrick was arrested for this, was he working at the time?
Yes, he was working at the Collins Street Bakery.
Okay, and do you know how long he had that job?
No, not at the time, ma'am.
Okay. Do you know, does he have any money in an account, or is that $1,500 that you were talking about the money that y'all have together?
That's what we have together.
Okay. Now, do y'all have any children?
Yes, ma'am. We have 3 now. 3 is here and 1 on its way. That's due in August.
In August, okay. And what are the ages of your other 3 children?
It's 15, 8, and 2 8-year-olds.
Okay, so you actually have, I'm sorry, do you have 4 kids then, or?
Is 1 on the way. The 4th one is not here yet. She'll be here in August.
Okay, so you have a 15-year-old, 2 8-year-olds, and then 1 on the way.
Yes.
Okay, got it. Is there anybody else that's trying to assist with bonding Kendrick out?
His cousin that I believe.
Okay. And have they gotten together any money?
Not that I know of, ma'am. Okay. I don't have to call and ask.
Okay. But he's been in custody since March 18th, and no one's been able to bond him out. Is that right?
Yes.
Okay. Are you wanting him to be out to help you with this new baby that's on the way?
Yes, ma'am.
When he is out, is he normally helpful to you and the children at home?
Yes.
And do you also need his financial assistance for him to get out and work and contribute to the family as well?
Yes, ma'am.
Prior to you getting this job that you just got, had you been working before, or were you not working?
I wasn't working.
Okay.
I was a stay-at-home mom.
And so you're due in essentially a couple of months, is that correct?
Yes, ma'am.
Okay. And so are you asking this judge to reduce the bonds significantly to an amount that you might be able to make to secure his release?
Yes,
And if he is released, will you do everything that you can to make sure that he shows up for any court hearings that he has coming up?
yes, ma'am.
Okay, do y'all have any kind of transportation?
Yes, ma'am.
What kind of transportation?
We got a 2005 Monte Carlo, and I got a 2012 Ford Fusion.
Okay. Do y'all own your own home or do you rent?
We rent.
And how much is the rent a month?
It's $650 a month.
$650?
Yes, ma'am.
Are you currently on any government assistance?
No.
And how old is Kendrick?
He's 36.
I think you know for the questions, Your Honor, pass the witness.
Say, have any questions?
Yes, Your Honor, if I might.
Yes, sir.
Ms. Thomas, how long have you been with Kendrick?
A year.
So those children that you mentioned, the 15-year-old and the 2 8-year-olds, are they his children?
2 of them are, and 1 is mine.
Okay. I'm a little confused as to how you could have which one is his, the 15 or the 8-year-olds?
He got a 15-year-old and he got an 8-year-old, and the other 8-year-old is mine.
Okay, so I'm a little confused as to how he can have a 15-year-old and you've only been with him for a year.
No, two of these kids is his. That was before me and him got together, sir. He came with 2 kids and I came with 1 child.
Okay, so they're not your children, they're his children.
Yes.
Okay, thank you. I'm sorry, I was very confused. So during the year that you've been with him, were you aware that he was on parole?
Sir?
During the year that you have been with him, were you aware that he was on parole?
Yes.
Do you know what he was on parole for?
No, because I didn't ask.
Were you aware when you got with him that he had previously been to prison for possession of a controlled substance?
No.
Were you aware before you got with him that he'd been previously convicted of assault family violence?
No.
And that in fact, he'd also been convicted of assault family violence with a previous conviction?
No.
He didn't tell you those things?
No. Because I feel like that shouldn't matter if a person
Objection,
changed or whatever.
non-responsive.
Well, no.
Ma'am, you may not, just wait for the next question.
That's all I have, Your Honor. I'll pass.
All right, Ms. Beatty, anything further of this witness?
Nothing further, Your Honor.
Okay, any other witnesses?
No other witnesses, Your Honor, we rest.
I always I like to look at a criminal history, but it's just, other than that, does the state have any evidence to present?
Your Honor, I would ask that, given that these are indicted, that the court take judicial notice of both files, including the indictments and the probable cause affidavits that have been previously filed.
I will take judicial notice of the indictments with the enhancements. I do not have the probable cause affidavits in the court's file.
Okay.
So I can do half of it, but not all of it.
Yes, Your Honor. As far as the court reviewing the criminal history, how do we normally get that in front of the court?
Just in person, and then
Okay.
I've actually will then destroy it after that. It will not be placed in the court's file.
If the court is okay taking this under advisement, then during the, when Mr. Price gets back with us during the Stevens plea, I will bring the criminal history to the courtroom.
Yes, thank you.
Yes, sir.
All right. I believe that concludes both these hearings. Thank y'all.
Thank you, Judge.
Yeah, but that's not till 3. I guess then the only, well, who we're waiting on for 1:30 is Dylan Stevens. And then we'll take up the other case, Bunch, at 3 o'clock. If you just want to hang tight, all on Mr. Stevens.
Okay.
Thank you, Judge. I'm gonna log out and I'll jump back on at 3.
Wait, hold on a second. Before you, are y'all able to do Bunch now, or do you want to wait till 3?
Date's ready whenever the court calls the case. But I know it was Mr. Perkins' request at 3, so I'll not.
Yeah. Mr. Perkins, are you ready to go now?
Judge, our request that Mr. Bunch be the only one in hearing vicinity when we do the plea was the reason that we asked that it be at 3 o'clock. As long as there's nobody else on the jail chain or waiting to come into the room, I don't have any problem with it.
Paul, is just you and Mr. Bunch if he comes in?
Okay, I still have Stevens in here.
Okay. There's your answer.
Thank you, Judge. I'll jump off and jump back on in about 10 minutes till 3. I'm here if somebody wants to send me a text message. If you need me any earlier than that, I'll jump on.
Okay.
Thank you, Judge.
Judge, since Ms. Schumer is doing that last plea, if it's okay, I'll go ahead and bring you that history.
That's fine. Thank you.
I'm on my way.
And since I was paying no attention to anything anybody just said, what are we doing now?
Sound like me.
You've agreed to handle everything for the rest of the year.
Yeah. Mr. Wolf's going to bring me the criminal history on Mr. Thomas.
And you're waiting on Mr. Price to do Mr. Stevens.
Yes.
Oh, yes.
Yeah, CPS.
Did we decide what we're doing on Barneson?
The court has taken that under. Have you read the messages I sent you on chat?
I looked at that. I had no idea what you were talking about.
If you were here on time, you would have heard what I was talking about. I'm kidding. The court's taking it under advisement. We made our argument.
Oh, that's what that is over there. Okay.
Yes. But did I type it wrong? I was typing in a hurry.
No, you typed it right. I was just like, I thought maybe that was from a different day. I don't do this chat thing very often, so I was a little confused.
Well, you have your choice. It's that, or I put a hole in the wall so I can yell at you.
Put a sliding door.
Sliding door. If I put a sliding door, then when I go up to it, I expect there to be coffee on the other side of it.
Oh.
Okay, I'm going to the courtroom.
Okay. Okay, taking that under advisement. So all we're doing now is waiting to do Mr. Stevens, correct?
Yes.
Okay.
Isn't it my number, sirs?
Oh, you are? Okay. Hey, Paul, I think Mr. Price is done with his CPR. So we can go ahead and do, Mr. Stevens.
Okay.
I think Mr. Wolf is doing, bringing me a,
Just hang on a second.
yeah, you can go ahead and get Mr. Stevens set up,
Okay.
but I'm not sure, is Mr. Wolf, Ms. Schumer, is Mr. Wolf doing this plea?
No, Your Honor, that would be me.
Oh, okay. Well, never mind then. We'll get it started.
Yeah.
Yes, Mr. Price and I had a long discussion on this one, so we're good.
All right. I spent my lunch making notes on all the docket because once I send in all these plea packets, they disappear and it's just easier to make notes and go from there. Okay. We'll go on the record and cause number D41028, State versus Dylan Jade Stevens. I have counsel for both sides present, defendants present. Mr. Stevens, is that your full and complete name?
Yes, Your Honor.
And Mr. Stevens, you stand charged in count 1 and count 2 of the offenses of aggravated sexual assault of a child. Is that your understanding?
Yes, sir.
And it's the court's understanding, sir, you're wishing to enter a plea of guilty to each count. Is that correct?
Yes, sir.
And you do understand what you're pleading guilty to?
Yes, sir.
All right. Mr. Price, do you wish to waive a reading of the indictment?
Yes, Your Honor.
Record and so reflect. Mr. Stevens, in this case, as to both counts, I have documents that appear to have your signature on them. They're written waivers, written plea admonishments, a waiver of your right of appeal, judicial confession, and an evidence discovery log. Did you sign these documents?
Yes, sir.
Did your attorney go over these documents with you?
Yes, sir.
Did you understand everything you've signed, sir?
Yes, sir.
You understand you have a right to have a jury trial and you're waiving that right?
Yes, sir.
You understand you also have a right to have the same jury assess punishment should you have been found guilty?
Yes, sir.
Are you a citizen of the United States, sir?
Yes, sir.
Each count, sir, is a first-degree felony. It carries a range of punishment anywhere from 5 to 99 years or life in the Texas Department of Criminal Justice Institutional Division and a fine not to exceed $10,000. You understand the range?
Yes, sir.
It's the court's understanding, sir, that you've entered into a plea agreement with the state through your attorney. Is that correct?
Yes, sir.
Now, the court will not agree to be bound by the plea agreement. However, if the court does follow the plea agreement, sir, it cuts off your right of appeal except by permission of the court. You understand that?
Yes, sir.
Are you entering your plea of guilty to each count freely and voluntarily?
Yes, sir.
Do you understand the consequences of your plea of guilty?
Yes, sir.
Your attorney is Mr. Price. Are you satisfied with his representation in this case?
Yes, sir.
Mr. Price, your client appears sane and mentally competent. Anything that your client has said or done that would cause you to believe otherwise?
No, Judge.
Court this time will find the defendant is sane and mentally competent. Court will find the defendant has freely and voluntarily entered his plea of guilty. He understands the consequences of his plea of guilty. The court will accept that plea of guilty and find the defendant guilty should the evidence prove him guilty or consider deferring a finding of guilt. I have in front of me states one, a judicial confession that's been signed by the defendant. Is the state seeking to have that exhibit admitted?
Yes, Your Honor.
No objection.
It's admitted. Before I go any further, I'm looking here in the court's file. I don't see I don't see on the docket sheet where there was ever an arraignment, nor do I see a waiver of arraignment in the court's file or scheduling order. Did we do that and it just didn't make it to the court's file?
No, he has not been arraigned.
Okay. Before we finish this plea, I guess we should go ahead and do that. Do you wish to waive arraignment?
We will waive arraignment in reading of the indictment, Judge. He understands what he's charged with and enters a plea of guilty.
In 10 days?
Yes.
Okay. All right, so now we'll fast forward back the other way. Again, I've already admitted the exhibit, and the state have recommendation in this case.
Yes, Your Honor. The state's recommendation upon approval with the court's granting is the defendant is placed on probation for 4 years for deferred adjudication. He will have $890 in fines, and that fine cost is the $500 fine, the $100 child abuse prevention fine, the $5 a month for the sex offender registration, and the $50 to the Children's Advocacy Center. There is 120 hours of community service. There's sex offenders registration according with probation and the standards that they have there. The defendant is take a hair strand test, drug offender education program, and he is required to register during the time that he's on deferred.
Okay. That Mr. Price, is that
That's our understanding as well, Judge.
all right, Mr. Stevens, you understand you have a right to petition the court?
I'm sorry, Judge, you're cutting out.
Okay. What about now?
That's better.
Mr. Stevens, you understand you have a right to petition the court in the future for an order of non-disclosure.
Yes, sir.
At this time, the court will make findings in both counts if the evidence substantiates finding you guilty of the offense alleged in each count in the indictment. However, the court will defer finding of guilt in both counts for a period of 4 years. During this 4-year period, sir, you are placed on community supervision where you're ordered to comply with all terms and conditions of probation. Do you understand that?
Yes, sir.
Mr. Stevens, do you read and write the English language?
Yes, sir.
Make sure you read through this order. It'll include the general order and then the sex offender order, the requirements for that. If you have any questions or concerns, you need to ask your attorney or the probation officer that you're reporting to. You understand that?
Yes, sir.
Sir, do you live here in Navarro County?
Yes, sir.
All right. You'll be reporting to an officer here. Mr. Stevens, I'm sure that your attorney, Mr. Price, went through the pros and cons of a deferred. I mean, the pro is that you don't have a conviction for the assault offense. The downside, sir, is if you fail to comply with terms or conditions, and there are a lot of them, that if you don't comply, the state can file a motion to adjudicate. And if that's granted, then you have a felony conviction, plus you have the range of punishment, and it's only available to the court, not a jury, but to the court of anywhere from 5 to 99 years or life in TDC. Do you understand that?
Yes, sir.
So I think it's important that you find out what you can do and what you can't do. And I would find that out today and then continue to ask questions as you go along these next 4 years. If you ever had any doubt, ask the probation office, okay?
And Your Honor,
Yes,
this all runs, count 1 and count 2 all run concurrent.
yes, thank you. All right, Mr. Stevens, do you have anything else pending in Navarre County?
No, sir.
Actually, Judge, if Ms. Schumer, make sure we get those other cases dismissed, that, you consolidated them into this one.
Yes, yes.
Thank you.
Are they still showing on the jail?
Yes,
Okay, we'll get that taken care of today, Your Honor.
thank you.
Okay. So, sir, you should be discharged from the Navarre County Jail. And in this case, you've waived your right of appeal. That concludes this hearing. Someone from probation, though, is going to come on here briefly and tell you when and where to report. Ms. Jock? You're on mute.
Can you hear me?
Now we
Mr.
can.
Stevens? Hello?
Yeah, hello? I didn't hear what
Okay.
you-
Once you're released, you need to come over to the probation office. Do you know where that is?
Bob Berkshire, yes, ma'am.
Correct. Okay. So as soon as you get released, then today, come over here. We close at 5 though, so
Yeah, somebody said if I get out after 5, that it comes straight in the
in the
morning.
morning. Yes,
All
that's
right.
correct. All right. We'll see you then.
Okay.
Well, once you get the thumbprint, I'll call you back up to process it.
I'll take up the final case, Mr. Bunch, about at 2:30, if that's okay with y'all.
30?
Yes, 2:30.
That's fine with me, Judge.
Okay, we'll be back.
Thank you.
Alrighty.
Thank you, Judge.
Judge, you said 2:30? 3.
Yes.
Okay. Thank you.
Maybe. Mr. Perkins? Mr. Perkins is not there. I'm just talking to myself, aren't I? This is how I keep myself entertained.
I'm listening.
Yeah. Melissa, do you mind sending Mr. Perkins a text? And I think he said he asked that earlier. And then I guess we can get Mr. Bunch.
Judge, I sent him an email. I do not have his phone number, so I didn't know who he was referring to.
Okay. I don't have his number either.
Mr. Bunch,
He may be there.
they're waiting on him, but.
Hello, Judge. I'm back.
Okay.
Hello, Wesley.
Hello.
Okay, before we go on the record, I just want to make sure I'm clear on the aggravated sexual assault of a child. I showed the punishment range was listed as 15 to 99 or life, but I don't see a prior.
Judge, the state was had told me that they were that they would add that prior if we went to trial.
Oh, okay. So it's still just a first degree? No,
Yes, Judge.
Okay, gotcha. I just thought it was on the plea packet, it was checked, so that's what kind of.
I filled it out based on the state's telling me that if we went to trial,
Okay,
that's what we would be.
gotcha. But as of right now, it's a first degree, 5 to 99 or life. Okay, and before we get started, I'm just trying to make sure everything's in a row because has there been a waiver?
I believe we did a waiver a long time ago, Judge. Waiver of agreement.
Yes, y'all did. It's just weird not having writing in the file when you open it up, and so. Okay. This is, we'll go on the record and cause numbers D40450 and D40452, both style state versus Wesley Allen Bunch. I have counsel for both sides present, defendants present. And Mr. Bunch, is that your full and complete name?
Yes, sir.
Mr. Bunch, it's the court's understanding that you're wishing to enter a plea of guilty in both of these cases. Is that correct?
Yes, sir.
One of which is aggravated sexual assault of a child. The other is indecency with a child by sexual contact. Is that what your understanding is that you're pleading guilty to today?
Yes, sir.
And Mr. Perkins, do you wish to waive a reading of the indictments in both of these cases?
I do, Judge.
Record can so reflect. Mr. Bunch, in both of these cases, I have documents that appear to have your signature on them. They are written waivers, written plea admonishments, a waiver of your right of appeal, a judicial confession, and an evidence discovery log. Did you sign these documents?
Yes, sir. I did.
Do you understand the documents you signed, sir?
Yes, sir.
You understand in both of these cases, and your attorney went over these documents with you, is that correct?
Yes, sir.
All right, and you understand in both of these cases, sir, you have a right to have a jury trial, and you're waiving that right.
Yes, sir.
You understand you also have a right to have the same jury assess punishment should you have been found guilty.
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
The aggravated sexual assault of a child is first-degree felony. It carries a range of punishment anywhere from 5 to 99 years or life in the Texas Department of Criminal Justice Institutional Division and a fine not to exceed $10,000. You understand the range?
Yes, sir.
The other case, sir, is a second-degree felony, punishable anywhere from 2 to 20 years in the Texas Department of Criminal Justice Institutional Division, and again, a fine not to exceed $10,000. You understand the range?
Yes, sir.
It's the court's understanding on both of these cases, sir, you've entered into plea agreements with the state through your attorney. Is that correct?
Yes, sir.
Now, the court will not agree to be bound by the plea agreements. However, if the court follows the plea agreements, it does cut off your right of appeal except by permission of the court. You understand that?
Yes, sir.
Are you entering your pleas of guilty, sir, freely and voluntarily?
Yes, sir.
And do you understand the consequences of pleading guilty here this afternoon?
Yes, sir.
Your attorney is Mr. Perkins. Are you satisfied with his representation in both of these cases?
Yes, sir.
And Mr. Perkins, your client certainly appears to be sane and mentally competent. Is there anything that your client has said or done that would cause you to believe otherwise?
No, Your Honor.
Court this time will find the defendant is sane and mentally competent. Court will find the defendant has freely and voluntarily entered his pleas of guilty, that he understands the consequences of his pleas of guilty. The court will accept those pleas of guilty and find the defendant guilty should the evidence prove him guilty. In both these cases, I have states one, judicial confession signed by the defendant, state seeking to have those exhibits admitted.
Yes, Your Honor, for each cause number, we'll offer states one.
No objection, Judge.
They're admitted. Anything further from either side?
State rest, Your Honor.
Judge, briefly, I'd just like to just ask my client a few questions.
All right, Mr. Bunch, if you could raise your right hand. Do you swear or affirm the testimony that you give in this case will be the truth, the whole truth, nothing but the true self you God?
Yes, sir.
All right, you may proceed.
Wesley, you and I have had opportunity to meet on these cases on several occasions, haven't we?
Yes, sir.
Okay. And you also got to meet with an investigator and an expert on this case, correct?
Yes, sir.
And you understand that you have an option and a right to go to a jury trial on this, right?
I do, but I don't feel like y'all think it's in my best interest.
Okay. Okay. You know, we've expressed our opinion on the case to you, haven't we?
Yes, sir.
Okay. And you're choosing to follow that legal advice, correct?
Yes, sir.
Okay. And but you understand you're doing that freely and voluntarily, that if you decided to go to a trial, that we would raise every legal defense that we could come up with.
More or less, I go along with that.
Okay. All right. Pass the witness, Judge.
Any questions?
Bunch, you understand that if these cases were to go to trial, that the state could file, and I'll tell you in all honesty, would file a motion to stack any sentence that you might get from a judge or a jury. So the accumulation of these cases could be between 5 to 99 or life on one and an additional 20-year sentence on the other, and those could be stacked. You understand that?
Yes, sir, I understand.
And you understand that as part of this plea bargain agreement, I've agreed not to stack these cases.
Yes, I understand.
Pass witness.
Nothing further, Judge.
All right. That being the case, the state have recommendation on the aggravated sexual assault.
Yes, Your Honor, based on the defendant's plea of guilty and the evidence introduced, we're asking the court to find him guilty of the offense alleged in the indictment, sentence him to 17 years of incarceration in the institutional division of the Texas Department of Criminal Justice. We're not seeking a fine. However, court cost in this matter of $390. In addition, the defendant would be required to register under Chapter 62 as required by the Code of Criminal Procedure. The defendant is entitled to 308 days credit against this judgment.
Mr. Perkins, is that you and your client's understanding in this case?
Yes, Judge, and I believe there was also a stipulation that he was to have no contact with the victim in this case.
Okay.
And that was something that was expressed to me by my client. That's the only person that he's not allowed to have contact with. He will be able to have contact with his children, his grandchildren, that sort of stuff.
Okay.
That's correct.
In this case, sir, I'll find you guilty of the offense. Based on the evidence, I'll find you guilty of the offense alleged in the indictment. It's the judgment of the court. You're sentenced to 17 years in the Texas Department of Criminal Justice Institutional Division with court costs to be assessed. Any reason why sentence should not be pronounced?
No, Your Honor.
Sir, you are sentenced to 17 years in the Texas Department of Criminal Justice Institutional Division. You're remanded to the custody of sheriff, who will transport you to the appropriate facility, begin serving out the sentence. This sentence begins today. You are given credit on the sentence of 308 days, and any day thereafter you're awaiting transport to TDC. This case will run concurrently, sir, with any other sentence you may receive out of this court. In this case, sir, you've waived your right of appeal. Say have recommendation in D40452.
Yes, Your Honor, based on the defendant's plea of guilty and the evidence introduced, we're asking the court to find the defendant guilty of the offense as alleged in our indictment, sentence him to 6 years of incarceration in the institutional division of the Texas Department of Criminal Justice. He is again entitled to 308 days credit on this case, as it will run concurrently with the sentence previously handed down by the court.
Mr. Perkins, again, is that you and your client's understanding?
Yes, Judge, that's our understanding.
Mr. Bunch, based on the evidence the court will find you guilty of the offense alleged in the indictment. It's the judgment of the court that you are sentenced to 6 years in the Texas Department of Criminal Justice Institutional Division. Any reason why a sentence should not be pronounced?
No, Your Honor.
Sir, you are sentenced to 6 years in the Texas Department of Criminal Justice Institutional Division. You are remanded to the custody of sheriff, who will transport you to the appropriate facility, begin serving out the sentence. The sentence begins today. You are given credit on the sentence of 308 days, and any day thereafter you're awaiting transport to TDC.
Your Honor, if I might.
Yes, sir.
I should state for the record, there are not victim impact statements returned on either of these cases, but the plea agreements were discussed with the victim's family, and they are aware of and in agreement with them.
Thank you for notifying the court of that. All right. In this case, sir, you've waived your right of appeal. That concludes this hearing, and I guess I'll do the revocation now. Okay, this is cause number D37348, State versus Wesley Allen Bunch. I have counsel for both sides present, defendants present. Mr. Bunch, is that your full and complete name?
Yes, sir.
Are you the same individual that the court placed on community supervision back in 2017?
Yes, sir.
At that time, the court ordered that you comply with terms and conditions of probation, and since that time, the state has filed a motion to revoke probation, alleging that you violated terms and conditions of probation. Is that correct?
Yes, sir.
The court understands that you're wishing to enter a plea of true to those allegations. Is that correct?
Yes, sir.
And do you understand the consequences of pleading true to those allegations?
Yes, sir.
Mr. Perkins, do you wish to waive a reading of the motion?
I do, Judge.
Record can so reflect. Mr. Bunch, I have documents in this case that appear to have your signature on their written waivers and written plea admonishments on revocation, probation, a judicial confession, and a waiver of your right of appeal. Did you sign these documents?
Yes, sir.
Did you understand everything you've signed, sir?
Yes, sir.
You understand you have a right to have a contested hearing and you're waiving that right?
Yes, sir.
Your attorney again is Mr. Perkins. Are you satisfied with his representation?
Yes, sir.
And Mr. Perkins, your client again, still remains to be, or appears to be stated mentally competent. Anything he said or done that would cause you to believe otherwise?
No, Your Honor.
Court this time will find the defendant is sane and mentally competent. Court will find the defendant has freely and voluntarily entered his plea of guilty, that he understands his plea of true. Sorry about that. He understands the consequences of the plea is true. The court will accept that plea of true, take appropriate action based on the evidence. I have in front of me states 1, a judicial confession signed by the defendant. State seeking to have that exhibit admitted.
Yes, Your Honor, I'll offer states 1.
No objection.
It's admitted. Anything further from either side?
State rests.
No, Your Honor.
They have recommendation.
Yes, Your Honor, based on the defendant's plea of true and the evidence introduced, we're asking the court to find the allegations in our motion to be true, proceed to revoke the defendant's community supervision. We ask that the court assess a punishment of 5 years in the institutional division of the Texas Department of Criminal Justice, as was originally assessed by the court. I will note for the court that the judgment revoking does say that the sentence in this case is reformed. I'd suggest that the court can simply strike out yes and write no, since the court will be assessing the punishment that was originally assessed at the initial hearing, placing the defendant on community supervision. Court cost owing in this case are $474, and the defendant is entitled to 308 days credit. As with the previous judgment, previous 2 judgments, this case will run concurrently with both D40450 and D40452, on which the court has recently pronounced sentence.
All right, Mr. Perkins, is that you and your client's understanding?
Yes, Your Honor.
All right, sir. Based on the evidence, the court will grant the state's motion to revoke probation. It's the judgment of the court, sir. You're sentenced to 5 years. The Texas Department of Criminal Justice Institutional Division. Any reason why sentence should not be pronounced in this case?
No, Your Honor.
You are sentenced to 5 years in the Texas Department of Criminal Justice Institutional Division. You'll be remanded to the custody of sheriff who will transport you to the appropriate facility, begin serving out the sentence. The sentence begins today. You are given credit on the sentence, sir, of 308 days, and any day thereafter you're waiting transport. It'll run concurrently with the other 2 sentences you just received. Sir, the bailiff's going to come over and get your prints on this judgment as well as the 2 other judgments here in a moment. And I believe at this time, sir, in this case, you've waived your right of appeal, and that concludes this hearing. Melissa, before I forget, can you send this revocation judgment back to me so I can make that appropriate change?
Unfortunately not. That's with the clerk's office and been processed.
Okay,
Sorry.
that's fine. I'll just get them to do it. Thank you. All right, anything further? I think that's it.
No, Your Honor, thank you.
Nothing from the defense, Judge.
Okay, y'all have a good rest of the day.
Thank you, Judge.